So, good morning, everyone. I see everyone fresh, ready to start a hard day on one aspect of a topic we've been discussing for the past 2 days. We will focus today on dispute settlement. So that'll make some people happy, at least 2 on this board. I'm happy to be here. So I want to thank the organizers for inviting me to be in this conference. I've worked on these issues a long time ago, and I'm glad to be back to work on them again. So today, I see some very relaxed faces. Those spoke yesterday, you know. So you bear with us as we sort of take the relève this morning and today, all day. The panel, this morning's panel, of course, has to do with dispute settlement of conflicts. I noticed that it's entitled, maybe, I don't know if it's on purpose or because it's been done by international lawyers, settlement of conflicts through international courts. So at this point, it's not dispute settlement in general, but it's international courts, and I wonder why. We'll see. We have 4 very distinguished colleagues coming from different areas of law who will talk about some issues. On the panel this morning, and taking the floor will be Christian Tams, Professor Christian Tams first. He's a professor at the University of Glasgow, an academic member of Matrix Chambers in London. So there we have academics and practitioners. I think we're going to come back to that during the day. He holds a PhD from the University of Cambridge, has been working on international courts and tribunals, especially the International Court of Justice. I think we sat in a conference some time ago on the legacies of the Permanent Court of International Justice. So he will be speaking on what is for us the Permanent International Court. Then we will move on with 2 mixed arbitral tribunals and the peace treaties. So that has something to do with the peace treaties, with, of course, Professor Hess. You all know Professor Hess. I will not introduce him again, but just to thank him for inviting me. And Professor Marta Requejo Isidro, who is a professor of private international law at the University of Santiago de Compostela in Spain. But I understand she is now part of the House, as I heard yesterday, so she's a researcher here. And finally, I'm starting to understand why this is a house, Helen. I've been hearing about it, but I didn't know before coming here. So. And finally, Dr. Jennifer Balint, who comes all the way from Melbourne. She's an associate professor in social legal studies, so we have a palette of various people working in criminology. She is the author of Genocide, State Crime and the Law, so I think it's a very interesting perspective that we'll probably hear from Jennifer in this presentation. So I will immediately give the floor to Professor Tams, Christian. You know the rules, 20, 25 minutes we've been told each one, to speak on I don't know if it's the Permanent Court of International Justice or the Permanent Court of International Justice or the court. But he has the broad topic. We'll see how he figures that one out. Thank you, Christian.
Thank you. Well, thank you, Fortini. Thank you to the organizers for inviting me to be in the house, as I think we're now calling it. It's good to be part of that club. And it's good to be speaking to you. Welcome, good morning from my side as well. The topic, as has been indicated, is the Permanent Court of International Justice, trying to stress all the words in the title. It puts us in the focus on binding dispute resolution, which is the topic for our morning panels. And of course, in that broader topic, which is broken down into 5 or 6 interventions, I do think the Permanent Court of International Justice stands out, not only because it's most likely, at least for the international lawyers, the court that most of us are somehow familiar with, which makes it difficult for speakers, but also because it's the first global court of potentially general competence, and the one court that is referred to as the World Court. The World Court symbolized, or the long-cherished dream of many, and is at the heart of peace through law projects. At the same time, we see in the creation and in the experience of the Permanent Court changes in the perception and operationalization, if you want, of peace through law ideas. And it's that aspect which I will want to emphasize, trying to say something new on a well-worn topic. Now, what I have in mind is really sort of speak to two issues and then sort of conclude. The first is the positioning of this court in the post-war ordering of the Paris Peace Conference and related agreements. The second is a summary of the operation of the court in the League era. And then sort of after that, there'll be sort of a short comment on the legacies, takeaways for today from the operation of that court. Now, the starting point for all this is a new beginning. The post-war settlement, with some delay, resulted in the creation of the first World Court, the establishment of the Permanent Court, not part of the League, as we were told yesterday, but envisaged in Article 14 of the Covenant, and set up fairly quickly in 1922, operating from 1923. And all this was no mean feast, because the League succeeded in creating such a court where prior attempts had failed, including at the Hague conferences. It set up a proper world court, competent to render binding decisions in disputes between states, and many saw this as the culmination of a long process of establishing the rule of law in international affairs, the rule of law over states internationally administered by an impartial body. And it's that perspective which remains prominent to this day, and it sees the PCIJ as really the natural, logical consequence of a process of moving towards arbitration in the 19th century, the Alabama claims, a regular practice, the Hague Peace Conferences that sets up an arbitral framework or a framework for the settlement of disputes between states. But all of this stops short of setting up a proper permanent institution. And this is where the League succeeds, sets up this court, and aptly sets it up in a palace dedicated to peace in the Palais de la Paix in The Hague. Now, in all this, it's clear that the Permanent Court is really sort of part and parcel of peace through law projects. But I think, and this will be my first substantive point, that when we look at it, we need to also appreciate that it marked a change in how peace through law would be perceived. The setting up of the court in the post-World War order marked a change in the vision of peace through law compared to the projects of peace through law of the 19th and 20th century, early 20th century. Now, peace through law comes in many forms. Disarmament, collective security, world government ideas. Yesterday we heard about Unidroit and its claim to do peace through law. But I think the 19th century and also the early 20th century really focused on peace through law as a form of peace through binding dispute resolution. Courts took center stage in peace through law designs. In Mark Mazauer's words, the arbitration and adjudication movement was the single most influential strand of internationalism. And the PCIJ needs to be seen against that background of a spirit that looked at peace through law primarily as a task for international courts establishing the rule of law. And to recapture that spirit or that background, let me quote a short passage from a small work by August Strindberg, the German lieutenant, which I think puts us into the mind frame of how we should perceive peace through law from a 19th century perspective. It's a passage that takes us to the 1870s, not to Luxembourg, but to close to Geneva, to Vevey, on the shores of the Lake Geneva. And there we see a German lieutenant, von Bleichroden, and his wife, and they meet with other guests in a hotel. And while they discuss politics, and here comes the quote, "The dark steel-blue evening sky was cut through by a streak of light, and above the low-lying Savoy shore there rose a rocket of enormous size before it exploded and spread out something like a white cloud, which assumed a four-cornered rectangular shape, a flag of white fire. A moment after, there was another report, and on the white flag appeared a red cross. All the parties sprang up and hastened into the veranda. "What does it mean?" they asked. Startled, no one could or would answer. And now there rose a whole volley of rockets as if discharged from a crater over the peaks of the Voiron and scattered a shower of fire which was reflected in the gigantic mirror of the lake. Now you might say, what does all have to do with peaceful dispute resolution? Here comes the answer. Still Strindberg, still von Bleichroden. "Ladies and gentlemen," said the Englishman who was part of that party, raising his voice while a waiter placed a tray filled with champagne glasses on the table. "Ladies and gentlemen, this means, according to the telegram which I have just received, that the First International Tribunal at Geneva has finished its work. A war between two nations, or what would have been worse, a war against the future, has been prevented. The Alabama question has been settled, not to the advantage of America, but of justice, not to the injury of England, but for the good of future generation. Today, as an Englishman, I ought to feel depressed, because England had lost. But I feel proud on account of my country, as an Englishman always does, you know, but today I have a right to be so, for England is the first European power which has appealed to the verdict of honorable men instead of to blood and iron. And I wish you all many such defeats as we have had one today, for that will teach us to be victorious. Raise your glasses, ladies and gentlemen, for the Red Cross, for in this sign we will certainly conquer." Now that's Strindberg speaking about the Alabama arbitration, and this is a work of fiction, of course, of literature, but I do think it captures the spirit, and it captures the spirit that sees peace entrusted to arbitral tribunals and to courts as center stage actors in that process. And no wonder when half a century later the PCIJ was set up, many commentators shared that same vision and the enthusiasm of Strindberg's proud Englishmen. So James Scott Brown wanted the world to fall on our knees and thank God that the hope of ages is in the process of realization as the PCIJ was set up. And Eric Drummond, the League Secretary General, saw in the opening of the court the greatest mark in the progress of mankind. No pressure, no pressure. But of course, I think they got it all wrong. They missed a vital point in their enthusiasm. And this is my second point. In their enthusiasm, Drummond, Brown, and others did not want to see that the PCIJ, as set up after the World War, was very different from the supreme tribunals dreamed up by legalists or praised by Englishmen in Strindberg's novels. The PCIJ did not have compulsory jurisdiction. Unlike in 1907 at the Second Hague Peace Conferences, all the great powers insisted that jurisdiction would have to be based on consent. And importantly, and perhaps more importantly, the World Court was designed to operate on the margins of the new world order set up, not part of the League's machinery for preserving peace, barely integrated into the relatively ill-fated but still impressive collective security system. The League's founders were idealists too, but their idealism was not the idealism of legalists believing in courts and international tribunals. Their idealism centered on collective decision-making within international organizations. Not the force of law, but the strength of political action backed by public opinion were to ensure the League's success. And so the Covenant relies on mandatory cooling-off periods, on dispute resolution by international organs, on management and containing of disputes, on institutionalized sanctions. It didn't rule out courts. Of course, they were useful if parties had consented to their involvement, but nothing required them to do so. What the League set up was a watered-down version of Scott's Hope of Ages. A world court it did set up, but one with a relatively modest role in the overarching peace design. Now, Brown and Drummond didn't see that, but others did. So Elihu Root, a longtime mentor of James Scott Brown, saw it very clearly, and to him this view of the court, this more modest view, dominated. He was deeply disappointed with the relegation of legalist thinking in the new post-war order. And he said nothing has been done looking at the Covenant. nothing has been done to provide for the re-establishment and strengthening of a system of arbitration or judicial decision. We are left with a program which rests the hope of the whole world for future peace in a government of man, not of laws, following the dictates of expediency, not of right. Now, the truth is surely somewhere in the middle, between Scott's and Drummond's enthusiasms and Root's disappointment. But the views that I've selectively quoted mark opposite ends of the spectrum, and I think it's important, especially as we approach the centenary of the PCIJ and all the grand rhetoric that will mark it, that we appreciate that when the court was set up, not everybody was jubilant. Now, what then did the PCIJ make of all of this? What did states make of it, that new opportunity? The answer is again ambivalent, and it depends on how we look at the operation of courts. Let me mention two perspectives. The first is the most obvious one, on the court, the PCIJ as a dispute settlement agency. Now, did it contribute to the pacification of interstate relations? Did it do so with some measure of regularity and success? Well, as agents of dispute settlement, courts can, of course, only react. They need clients to provide them with cases, and perhaps we can go further and say courts, if they want to be agents of world peace, world courts need conflicts of significance that are referred to them. And on both counts, the PCIJ struggled. Its clients, states, had limited faith in binding judicial dispute settlement. There are three aspects to this. First, the PCIJ in its time had few cases and few clients. Over 2 decades of its active existence, it dealt with 33 contentious disputes, 1.5 per year. And its clientele remained decidedly European. In only 4 cases did non-European states appear. In 1 single case did a non-European state play a significant role, Brazil and the Brazilian loans cases. Now, this wasn't primarily a problem of jurisdiction, because contrary to what I've just said about consensual, the consensual grounding of jurisdiction, states did include in treaties in large number compromissory clauses that would have allowed recourse to the court, unilateral recourse. Also, states did in significant number subscribe to the optional clause system that permitted unilateral declaration accepting the jurisdiction of the court, as a form of anticipated consent. But these clauses were hardly ever used. As a second point, the substantive scope of disputes coming before the court was relatively narrow. Its decisions concerned a relatively limited set of issues. Maritime incidents of the Lotus type, treatments of aliens like Oscar Chin in Belgian Congo, but more than anything, the PCIJ was concerned with issues relating back to the Paris Peace Conference settlements. The territorial settlements, Silesian cases about which we'll hear, internationalization of the Kiel Canal, as in the Wimbledon case, rights of minorities, rights of institutions. Now, none of this was a bad thing, but it meant, and I think it affected, the character of the court. This was set up as a court to inaugurate a new era, but it was a court that in its daily work constantly looked backwards to the war settlements, to the previous war. And as a third point, and related point, it's fair to say, I think that, I'm simplifying a bit, but only a bit, I think, that the disputes that did come before the court were not necessarily the stuff for headlines. The bulk of the case law was fairly technical. A ship seized here, a university's claim for restitution of property rejected there, and then wonderfully entitled opinions, for example, on the competence of the International Labour Organization in regard to examination of proposals for the organization and development of the methods of agricultural production and other questions of a like character. Third advisory opinion of 1922. Now, in all this, I don't want to be as dismissive as I may have sounded. It's just to make a fairly straightforward point. With few exceptions, and the customs union between Austria and Germany is the prime example, states went to the PCIJ with disputes of limited political significance. The court shouldn't be blamed for this. Again, it depends on clients bringing cases to it. I only mention it to mark the contrast between prior debates about the role of courts and the reality of dispute settlement by the court once established. In 1899 and 1907, in Strindberg's quote that I gave, in 1920, the idea was of a court that would act as a guardian of world peace. The reality of the PCIJ in action was much more mundane. Ole Spearman, whose work foreshadowed renewed interest in the League and the PCIJ, observed this with clinical Nordic precision. And he said, in the political history of the League of Nations, the Permanent Court was but a footnote, partly because it did not address the main political issues of the day. Now, all of this probably sounds far too negative, especially for somebody who spends 2/3 of his life reading and writing on courts. And also I wanted to be ambivalent, so trying to redress that, let me add a caveat and then maybe a slightly different perspective that we can also take when we look at the operation of the court. Now, the caveat is really an attempt to shield the court from the cheap criticism that I've just set us up for. Now, of course, even without rendering decisions on the great political issues of the day, courts can be extremely useful. And, of course, we shouldn't belittle the relevance of so-called small disputes or conflict containment through going to court. Ian Brownlee, famous international lawyer from Britain, and one of the most prominent advocates in ICJ proceedings, is reported to have said, when asked how he spent his life, "I help small states prevent small wars." Now, Michael Callahan yesterday spoke about the League initiative dealing with terrorism on an operational level, probably also not the stuff of headlines, but extremely useful, and an exercise in trying to organize cooperation on a vital matter. I think by the same token, we could say that the PCIJ was successful on the operational level of diffusing tensions, diffusing conflicts, and settling disputes quite successfully. But it was not, and I come back to my main point, a court for the great questions of war and peace. It made a distinct and important contribution, but not on the issues that focused debates in 1899 or 1907. Now, if we look beyond the political history of the League, which was, of course, the focus of Spearman's quote from 2-3 minutes ago, then I think we can offer 2 or 3 further perspectives on the court. And I think this brings me to my final part of the talk. First of all, if we look at the PCIJ not from the perspective of a dispute settlement agency, but as an experiment, as an attempt in role definition, then I think it has had a much more significant role. Now, I think a useful perspective as we look at the League is not to see it as one great experiment, but as a series of experiments, great and small. And probably the PCIJ, if we link it up with the League, is somewhere in the middle, one of these mid-range, medium-level experiments. And I think it did do remarkable things in terms of defining the role of the international judiciary and of international courts, partly because it was the first permanent court of significance and potentially global reach that was around, and partly because it was pragmatic and pioneering in good balance. So it took decisions that would shape our vision of the international judiciary, from the mundane, the minutes of the first seating recorded discussion among judges, and a 6-5 decision between the members that they would wear robes when sitting. Robes which, in the view of one person who belonged to the minority, made them look somewhere between clowns and bishops. Now that's on the mundane side. On the fundamental side, the PCIJ's practice and experience and rule drafting helped organize proceedings, balancing respect for state sovereignty and effective organization of proceedings, balancing or fusing common law, civil law approaches into a truly international approach of managing international proceedings. On the structural level, if you want, just as the League of Nations civil servants needed to chart their course and move on from the idea of being delegates of states towards being truly international civil servants, so the International Court of PCIJ judges needed to define their role as international judges, as opposed to national judges that had been seconded to some international institution. So I think on all those matters, the PCIJ had a significant influence in defining the role of international courts and the international judiciary. Now, that you might say is still all pretty inward-looking, what has it done to the profession or to the niche segment of people who care about international courts. But I do think there's a further perspective, and this is sort of my final perspective. The PCIJ has also shaped and significantly altered our understanding of international law. And it was anything but a footnote in that respect. So with the PCIJ, the era begins in which we can begin to talk about judge-made law, in which courts, simply because they get repeatedly involved in dispute resolution and as a byproduct of settling disputes, can contribute to the clarification and development and systematization of rules of international law. Now, rules clarified not as in the pre-PCIJ days through diplomatic practice, possibly even scholarly writings, but crystallized in international dispute settlement proceedings. Now, in that vision of courts not as agencies for dispute settlement, but as agents of legal development, I think the PCIJ was highly influential, and it pioneered a role that courts to this day play, and which often sort of probably is more relevant than the dispute settlement role that they were initially set up to play. And it's significant, I would say, that despite the relatively small number of cases and despite the relatively small set of issues that were litigated before the PCIJ, that was clear almost from day one. Well, or let's say almost from year 10, because it's 10 years after the PCIJ became operational when Lauterbach published the study on the development of international law by the Permanent Court of International Justice, which set the tone for a flurry of publications on the rule-making, rule clarification, developmental function of international courts. So to conclude, a court in operation that plays a relatively modest role compared to the great expectations as a dispute settler, but is nevertheless useful, but a court that invents the concept of an international judiciary or shapes it, and shapes also our vision of international law. A final point on legacies, sort of by way of conclusion. And it's really sort of three quick, more or less, points that I want to throw out, maybe to set us up for a discussion on these issues. The first of these is that in one sense, I think we've stuck very much with the idea formulated or put into operation in the post-World War I settlement. I think since the time of the PCIJ, the linkage between courts and war and peace, the idea that world peace would be entrusted to world courts, has, if not given up, has continued to be relegated. We've moved away from the 19th century utopianism, for better or worse, probably overall for better, but for worse also because it means giving up a certain idealism that people in the 19th century and 20th century, I think, did feel. Today, now, no one sort of despairs at the absence of a court if one country wages war against another. We despair at the absence of effective collective sanctions or a machinery that can respond quickly. We're firmly focused, I think, on questions of war and peace, on collective security systems, on institutions, and that began, I think, that mindset took hold from the 1920s onward when a first collective security system was set up, even though it didn't operate in the way people wanted it to operate. So I do think, as compared to the debates of 1899, 1907, courts have remained on the margins of questions of war and peace. And we talk about how they define their role on the margins, just as during these days people in New York discuss about whether jurisdiction over the crime of aggression should be activated for the ICC. But these are not questions of preventing war, but of dealing with aspects of war in retrospect. A second point, in which the model of a court set up in 1922-23 has not been quite as influential. The PCIJ has, of course, has survived as the ICJ in its second incarnation. It continues to exist as a world court of potentially global consequence, of broad but thin jurisdiction. But I think it has become increasingly exceptional because the numbers of courts that have been set up in the second half of the 20th century and increasingly towards the end of the 20th century have been more targeted in their jurisdiction, have mandatory jurisdiction over more tightly defined issues. So the idea of a court that is generalist retains its charm, but has lost its appeal in the practice of courts of states which have gone for the WTO, for investment tribunals, for the law of the sea tribunal. A final point, and this is literally the final point I'm sort of noticing, sort of worried glances from the side that I pretend to ignore. As regards the function of international courts, I do think the PCIJ has really set the tone. The idea that we would need to think of courts as not just agents of dispute resolution, but also as shapers and molders of the law. This is something which we've sort of internalized since then. It's beyond dispute, wrote Armin von Bogdandi and Ingo Fenske in an influential study, that there is a role for courts beyond dispute settlement. And I think it is beyond dispute largely because it's become clear from the first days of the PCIJ that even where they settle disputes of mid-level or low-level significance, they perform an extremely useful function for conflict containment and for the systematization of international law. Many thanks for your attention.
Thank you, Christian. Yes, I was squirming. I think you were only 5 minutes over, but I wanted to let you finish because I was very depressed in listening to the first half of your speech. So I wanted to see where you were getting at. So you somehow, but I think it will give us a lot to discuss. So I will immediately give the floor to my colleagues, Professor Hess and Marta Requejo, for now we go into, yes, an aspect of tribunals that were linked actually to the Versailles peace treaties, the mixed arbitral tribunal.
Do we have everybody? Yes. Okay. So the First World War was not only the greatest war mankind had experienced so far. It had also triggered many adverse economic consequences for private commerce and for investment. In the course of the war, all the belligerent nations had adopted legislative measures against the so-called property of the enemies. According to these measures, trading with nationals of the enemies was generally prohibited, the property of these nationals was strictly controlled and often seized, and measures of sequestration usually applied to corporations and branches of foreign investors of the belligerent nations. As the national of enemies countries had been denied standing in the domestic courts, they faced default judgments and other detrimental decisions. So it was clear that the peace treaties had to put a remedy to this situation. The Versailles Peace Treaty addressed private rights and relationships in the so-called economic clauses, which is part 10 of the treaty, in Articles 264 to 312.
So the basic provision concerning the mixed arbitral tribunals was Article 304, which gave the tribunals jurisdiction to deal with disputes between private parties, also between private parties and state parties, relating out of the economic losses. And the basic substantive rule of the peace treaty was as follows, and it was very much backwards. So as far as allied creditors had been affected by measures of warfare, economic warfare, they got a substantive right of restitution and of compensation. The creditors from the central powers, however, were not in the same position. It was Article 297, which said in the first paragraph, the allied creditors have the right to restitution and compensation. But the second paragraph said that the creditors coming from the central powers lost their property, and the proceeds of the liquidation of this property should be used for the compensation of the other creditors. So it was an unbalanced system, and there was an additional issue. The substantive rights of the allied creditors had to be under general private international law by the courts of the central powers. They had jurisdiction to hear these individual claims, but there was a huge distrust on the side of the allied concerning the impartiality of the courts in Germany, Austria, Hungary, and Bulgaria, and finally Turkey. And this was the reason why these mixed arbitral tribunals were established. So let's look for one moment at the competences of those courts. And they had four main competences. The first one, brings us back a little bit to what we have seen yesterday in the presentations. There were ongoing contracts at the outbreak of the war, which were affected by the laws prohibiting any trade with the enemies. These contracts were stopped, but there were outstanding debts, and these debts were heard and settled by clearing offices, and their decisions could be challenged within the mixed arbitral tribunals by the individual affected. So here we had the original parties of the contracts being parties before the mixed arbitral tribunals. Second issue, restoration and compensation for property rights located in the belligerent states, which had been subjected to measures of so-called exceptional war measures. This was the economic war against enemy property. So here, restoration or compensation could be ordered by the mixed arbitral tribunals. And then there was a totally different competence, and one has to be quite explicit in this respect that the competences of the mixed arbitral tribunals were quite diverse. And this competence had to do with a specific situation in Poland, the transferred territories. And in the transferred territories, there was a right of the new states to expropriate property of German nationals, also Austrian nationals, located within those states. And they had a right to compensation, but they could challenge the compensation awarded by the national authorities, the Polish authorities, in the mixed arbitral tribunals. So this is a totally different competence compared to the two first ones. And finally, we have to come back again to the economic clauses, and allied creditors, they had an additional privilege regarding procedural rights. They were not obliged to start litigation in the mixed arbitral tribunals. They could also vote for German courts or for allied courts in order to enforce their rights given by the economic clauses. But there was a kind of review by the mixed arbitral tribunals regarding the case law of the German and the allied courts in order to implement the economic clauses. So 4 different competences, quite diverse. Ladies and gentlemen, do you have an idea where the mixed arbitral tribunals were located? Any idea where this nice building is located? It is a former Austrian embassy in Paris, which is called Hotel Matignon. So they started in Paris at a place which was, of course, not so easy for the German parties to litigate, and we will come back to this issue. Let me give you some figures and an idea where the many cases you were missing in the Permanent Court of International Justice were litigated at that time. So, there were many mixed arbitral tribunals. 36 different tribunals had been established, and they were all individually administered. So there was no overwhelming administration. Many individual courts, but never. What is going on here? Yeah. Nevertheless, there was a kind of, let's say, the staff of the courts was quite similar, as they were composed by arbitrators who were chosen by the 2 respected states, so Germany and France, Hungary and Romania, and there was a president who had to come from a neutral country. And these presidents quite often were the same persons. Why was it so? Well, let's look at some figures. And I think this is quite interesting to see how many and how different cases were heard by these courts we found an interesting article written by a German author, Schätzel, Jahrbuch Öffentliches Recht, 1930, which provides for some statistics. And if I may add one word, it was very nice to discuss with Mr. Appelding some of the issues. He will come back to one specific aspect of the mixed arbitral tribunals, and we exchanged a little bit our findings concerning the courts. So just look at the most important cases were between Germany and France, and you also had many, many cases between Germany and Poland. These figures are not absolutely correct. You have to be aware, because they were made in or given in 1930. The operation of the mixed arbitral tribunals ended in 1932 with a young plan, and I will come back to that. But what we can say is the bulk of the case law in the post-war period was in the mixed arbitral tribunals. But we will see it was only about dispute settlement, and it was not about establishing international law. So, let's briefly look at the organization of the mixed arbitral tribunals. I already mentioned the bench, the justices. Then they were supported by secretaries, which came from the different contracting states, and they had personal assistants. Especially the presiding judges had personal assistants because the case law was considerable. Some of the presiding judges had to deal with 50 cases per week, and they had to draft the judgments. So they needed some support. And it turned out that the national judges were not of great help in drafting the judgments because they were considered as more or less biased. It was not always the case, but nevertheless there was of course a kind of distrust by the German judge when the French one was drafting a judgment and vice versa. Then there were the individuals. They had their own standing in these mixed arbitral tribunals. They were represented by lawyers, but it was not absolutely necessary. And nevertheless, it is very often said that the individuals had their own standing, subjective rights, etc. This is true. But at the same time, when the whole story ended in 1932, states simply waived the rights of their nationals. And then everything was over. Whether compensation was paid to the individual parties was an issue of the home state of the individual. This was diplomatic protection, the old system. There were state agents in the proceedings, and they had a very interesting role because they represented the states in cases when compensation was directly claimed from a state, the second competence I alluded to, but they also assisted the individuals in bringing their claims, and they settled many of the claims there. So you have seen there were many claims pending in some of the mixed arbitral tribunals, and the state agents operated as an untechnical clearing, had an untechnical clearing function. They even elaborated forms to bundle claims, and there were sometimes very small claims. You have seen the case of the mixed arbitral tribunals between Austria and Italy. So these cases were about Italian workers who had been in Austria, the same situation applied also to Germany, who had left Austria after the outbreak of the war, and they left behind wages, unpaid wages, clothes, and personal belongings. These claims were not big, small claims, we would say, and they were compiled, settled directly by the state agents.
Now we move to the procedure which was applied by the mixed arbitral tribunals. According to Article 304 of the Vis-Peace Treaty, each mixed arbitral tribunal had to elaborate its own procedure, and actually they did it in such a detail that they were described as miniature civil procedural codes. The questions they addressed were questions such as the international organization of the tribunals, for instance, the headquarters, the rules of the proceedings, the principle of competence, or those principles related to representation, legal aid, costs, etc. And they also explain the unfolding of the procedure, the different phases, the regime of evidence, enforcement, and appeals. In this slide, what you can see is the first page of a dossier where you can follow the different phases of a procedure before a mixed arbitral tribunal. There were many similarities between the regulations of the mixed arbitral tribunals because every new one looked at the precedents as templates. The legal literature of the time was even able to identify 3 different models. Nevertheless, the procedures were not identical, and also, and this is a very interesting point, decisions were drafted in very different styles, following the style of the country where the mixed arbitral tribunal had the headquarters. So, for instance, you can see here a Belgian-German mixed arbitral tribunal decision with this vu que, attendu que. The following one is one of Anglo-German mixed tribunal. There's nothing about this, it's plain narrative. And the third one is, again, goes back to a civil law tradition, which is the German-Italian mixed tribunal. The procedures follow a similar pattern. The claims had to be filed with the tribunal within a limited period of time, mostly 1 year after the establishment of the mixed arbitral tribunal. The lawsuit had to clearly designate the facts, the pertinent legal provisions, and the evidences that were going to be used, and normally it was documentary evidence. Representation by lawyers, as Professor Hess has already said, was not mandatory, and often the state agents assisted the claimants in formulating the claims, and they even elaborated forms. There were nevertheless specialized lawyers who collected similar claims and brought them collectively before the mixed arbitral tribunals. And I think you...
There is one example I would like to give. It was in the German-French mixed arbitral tribunal, and one issue was the nationality and the eligibility of inhabitants of Alsace-Lorraine. So they were assimilated to French nationals. This was a specific doctrine which said they had a pending nationality. And the moment the German-French Arbitral Tribunal gave a judgment in this sense, it was reported by German authors that French agents went through Alsace-Lorraine and collected claims. So they asked farmers about whether there had been requisitioned, something like this, cars had been requisited, and so they brought more than 20,000 claims to the French-German mixed arbitral tribunal. It was a kind of ambulance chasing in the early 20th century.
Coming back to the procedures, one thing that we thought it was worth mentioning is a criticism of the mixed arbitral tribunals already at the time, the inequality of arms between the parties. There was an allegation that procedures were unbalanced, and this had to do with the seat of the arbitrations, which were mainly London and Paris, places where there was a palpable anti-German environment. The question of the language was also very important, the question of the language of the procedures. According to the Vis-Vis Treaty, it could be an election could be made by the Allied power among French, English, Italian, or Japanese, although they could agree otherwise. And in practice, most of the regulations choose the language of the Allied power. That meant that, apart from the greater difficulties that this generated for the German members of the mixed arbitral tribunal, also this was in the detriment of the litigant who could not use his mother language. So now we move to the legal nature of the mixed arbitral tribunals, which was, again, one of the most debated issues in the literature in the 20s and the 30s of the last century. There were 2 questions in this regard. The first one was whether they were national bodies or rather international bodies or even a tertium genus. And the second question was whether they should be considered as an exceptional jurisdiction or rather as a general one. And both questions had significant further impacts. I will only briefly address the question regarding the general specific jurisdiction, because the opinion was obviously associated with whether the mixed arbitral tribunal's competences were to be interpreted in an extensive or rather a restrictive way. And obviously, if you see it from the perspective of the German defendant and this idea of unbalanced procedure, it was important to know whether they could extend their competencies or not. Nevertheless, from the point of view of the mixed arbitral tribunals themselves, except for one decision which is considered as a milestone, who said that the jurisdiction was a general one, the prevailing view was that it was an exceptional jurisdiction, and this was also the prevailing view among the national courts. The second question was whether the mixed arbitral tribunals had a national or international nature. The scholars addressing this issue reached different conclusions depending on which was the departing point of view. If we look, or if they looked at the origins of the institution, they all agreed they were international institutions. On the contrary, if they addressed the question from the point of view of the function, they made different distinctions following the taxonomy of the controversies allocated to the mixed arbitral tribunals, which Professor Hess has spoken about before. So depending on whether a state was involved and what was the role of the state, then the mixed arbitral tribunal had an international nature, or depending on whether an individual was involved and whether he was acting on his behalf or on behalf of the state, the nature would be national or international. The interesting issue about this question of the nature of the mixed arbitral tribunals is that it had a direct impact on how to solve the merits of the disputes. The Versailles Peace Treaty said nothing about the applicable law, and obviously mixed arbitral tribunals were not judiciary bodies of any nation, so they had no lex fori. This led scholars of the time to a division. Those who characterized the mixed arbitral tribunals as internal state bodies subject them to state law, and in this regard they had different views. It could be the common law of the arbitrators, which was seldom the case. They very seldom had a common national law. The law of the state that a competent national court would have applied in case she had been seized of the affair, which for some authors would be German law, or cumulatively to the legal system in force in both states signing the agreement creating the mixed arbitral tribunal. Conversely, for the scholars who believed in an international nature and role for the mixed arbitral tribunals, they trusted that the arbitral tribunals would develop a common, even a universal system of conflict of law rules or even of material solutions, and I have to say from the outset that they were very much disappointed. They talk about an internationales Welt Privatrecht for international trade. This was the opinion of Grau. About einen überstaatlichen internationalen Privatrecht irgendwelcher Art, which was to be derived from public international law and the principles of personal and territorial sovereignty. This was the opinion of Zittelmann. Or they thought that the mixed arbitral tribunals could be able to find völkerrechtsgemäße solutions, which would be based on the minimum requirements imposed by public international law to private law. And these minimum requirements were referred to as überstaatliche international Privatrechtssätze, such as the recognition of vested right, connecting points which are generally accepted and can be even qualified as customary, such as the lex recitae for real estate rights, and this was the opinion of Gutzwiller. The mixed arbitral tribunals in practice acted pragmatically on a case-by-case basis. They did not stick to any method and they did not develop one single method. We could identify several attitudes. Some mixed arbitral tribunals addressed the merits of the dispute according simply to good faith and equity. Some avoided the applicable law question, for instance, when the system of the two states involved were assumed to have an identical material solution. They would apply the solution of one of the legal systems in presence, but without disclosing which was the connecting point. They would resort without further justification to connecting points. Or finally, some decisions were based on assumed general principles of law, such as the respect for vested rights, the application of the personal law of the deceased in succession matters, the law of the place where the contract is concluded for contractual obligations, or some other principles whose universal character would today be very much contested. And the result was obviously the fragmentation of the case law.
And this fragmentation is really a telling feature of the mixed arbitral tribunals. As we mentioned, they had different procedures. They had, within the Versailles Peace Treaty, very different areas of competences. And there was no possibility to have a second instance to come to some more coherent practice and case law. And even within the bigger mixed arbitral tribunals, where several sections had been established, the presidents were unable to meet and to agree on common principles. So it was about individual dispute settlement. But if one looks at a situation of today, where in investment arbitration we have a multitude of parallel investment tribunals, we can see that this experience had already been made by the mixed arbitral tribunals, and I find this quite interesting. And just to take up again the situation between the Permanent International Court of Justice and the MIT, there are of course some links. Finally, in the 1930s, there was even an international convention to make the Permanent Court and Court of Appeal for the mixed arbitral tribunals, Hungary, Romania. And you already mentioned one case of the Permanent Court. And the question was, of course, how did the Permanent Court see its relationship to the mixed arbitral tribunals? And the answer of the Permanent Court was quite interesting. He considered itself as a general court of jurisdiction. So the MIT had only very specific areas of jurisdiction, which was correct. And the Permanent Court also considered the mixed arbitral tribunal as tribunals not of the same level. So this argument, tribunals not of the same level, is also an argument which one can hear when it comes to the delineation between investment arbitral tribunals and domestic courts. And it's quite interesting that here the delineation is between domestic and courts and international tribunals, but when it came to the Permanent Court of International Justice, it was between the MIT and the court itself. Nevertheless, the same argument is used in both situations. Let us assess very briefly what has happened with the mixed arbitral tribunal. So it was a preferred way of dispute settlement in the 1920s and 1930s. They had the case law concerning the peace treaties, and they were finally able to settle many, many cases. Also, it came very quickly to an end by the Young Plan, with one exception. It's the Mixed Arbitral Tribunal for Upper Silesia, which we will discuss later on. There was, of course, a bias to the detriment of the creditors of the defeated states, and there were also some, let's say, procedural imbalances. So seat of the arbitration does play a role, language of the proceedings does play a role, but nevertheless, apart from that, one has also to assess that there was a fundamental fairness in the proceedings. The proceedings were quite modern and efficient in the sense that they had a preparatory stage and one hearing just to speed up the proceedings, and settlement was an important part of those proceedings. However, the fragmentation and the inability of the courts to come to general principles was a prevailing view in the 1930s and also 1940s. And after the Second World War, the idea of mixed arbitral tribunals was not taken up again. And what we found quite telling was the situation, or was not the situation, was rather a book, the Liber Amicorum Schätzel, so the one who had written the study about the mixed arbitral tribunals in 1930. And in his Liber Amicorum, there are very interesting articles, but no article about MIT. The same Liber Amicorum Gidel, the one who was the editor of the 9 volumes about the case law of the mixed arbitral tribunal. This topic had totally disappeared. However, since the 1980s, similar international instances for dispute settlement have reappeared. Nationality is a huge topic in investment arbitration. It was also a huge topic in the mixed arbitral tribunals. Fragmentation has come back. And so I would like, or we should stop here, because this is for the roundtable of this afternoon, but I would say this experience of the mixed arbitral tribunals is a very interesting one. Thank you very much.
Thank you very much. It's very interesting to see that nothing changes, and we will have a lot to discuss about differences and similarities of today. So, Professor Balint, International Criminal Justice.
Well, thanks very much. And again, I'd like to echo everyone's thanks to our organisers. It's been a really, I think we can all agree, a really rich and rewarding couple of days so far, and a really interesting gathering of people. Now, I've titled this International Criminal Justice, the Work of Translation. And I'd like to start with a family story from my Hungarian side of the family. So my grandfather's father, Julius, who was his favourite uncle, he was the one who taught him weightlifting and riding and all sorts of other things in the Hungarian countryside, was a member of the Hungarian parliament in the years before World War I. He was an independent. In his words, he was acting in the interest of and on behalf of the farmers and small landholders, one of a growing group of Jewish politicians who had been able to run for office due to enfranchisement at the turn of the century. His brother, in fact, had entered Parliament a few years before him. In early June of 1912, the government of the day, which was led by the Speaker and former Prime Minister, and to become Prime Minister again, Count István Tisza, was pushing through reforms that were deeply unpopular around providing further military support to Austria and refusing to grant universal suffrage. The opposition were using quite innovative tactics to obstruct legislation going through, and the government ended up bringing the police to keep out the opposition. Kovacs Julia, my great-great-uncle, sitting in the journalist gallery, already expelled for his disruption of the votes for the new speaker, jumped down and fired at Tisza, shouting, "There is still a member of the opposition." So that's Julius on the left. He then turned the gun on himself. Tisza was unhurt, and Julius was too, and the bullets not doing any serious damage. This story has been told many times. In fact, we always thought it was an urban myth until we discovered all sorts of documentary evidence. And in fact, if you visit the Hungarian parliament, you can see the bullet holes in the speaker chair. That's the bullet holes there. My mother, from the Viennese side of the family, hasn't always understood why my father's side takes great pride in this. Julius was tried, a major event by ticket only, and acquitted due to enormous public support, particularly his role in pushing for political rights for all Hungarians. Before 1918, only 10% of the Hungarian population could vote and hold office. And that's the New York Times article from the time. Later, Julius tried to save Tisza from assassination by soldiers returning at the end of World War I. And in fact, Tisza, in his testimony at Julius's trial, stated that the action was political and not personal against him, and that the action should remain in the parliament. Uncle Julius later managed to leave Hungary and ended up a refugee in America with his family. As someone coming from outside of Europe, yet with family history in it, this story is both a way of locating myself in this time, yet also, I believe, an apt place to start a discussion of justice, and particularly the space of international criminal justice that I've been asked to speak to today. And what I'm going to be focusing on is translation and understanding interstructural change. Suffrage, political rights, the substance of this was to be debated and negated over the years to come. So the question I'd like to start with today is, what work do we want law to be doing? So this is a quote that I've had up on my wall in my office for many years, that law should take as its most central question what kind of a community we should be. I've always thought that Uncle Julius avoided a lengthy jail term because of the perceived justice of his actions, that in fact law played a role in articulating these universal suffrage and political rights. My work has been very much focused on the constitutive role of law. So what does a socio-legal scholar, a social scientist, have to bring to a conversation, a discussion of international criminal justice and the Versailles Treaty? I've got complementary questions and focuses to those that we've been hearing over the last 2 days. I start with this concept of a foundational moment that I've used very much in my work, that these legal processes play really critical roles in establishing new normative frameworks, marking this moment between past, present, marking a way towards the future that we'd like to have. And as authoritative recognition of harms perpetrated, these judgments, these processes, these tribunals are critically important. In fact, of course, this is what our hope in law is based upon, that as a set of normative guidelines for a society, law can potentially initiate change. We see this great hope in the Versailles Treaty, and is also changeable when it does not reflect societal norms. We created a crime of genocide in the wake of World War II precisely for this purpose, and we held trials on the impact of the Nazi German strategy to, in fact, try and create this moment of change. The Versailles Treaty, the commissions associated with the Court of Justice, we've heard about the mixed tribunals. I think in many ways they can be seen as small and large moments of change, foundational moments. I was particularly struck yesterday in hearing about the origins of the ILO and the Social Justice Clause, Article 13 in the Versailles Treaty. So I think it's really important. I think this is the nature in which these articles were understood at the time. We see this as such, marking this moment between past, present and future. But foundational moments, however, of course, can be subverted and often are by political process. Law can fail to have a hearing. And the Ottoman courts-martial proceedings held at the end of World War I are a key example of this, and I just speak a little bit about these now. So the Ottoman courts-martial, this we can understand as the beginnings of an international response to crimes against humanity and genocide perpetrated during World War I. So this courts-martial was supposed to be international. Several articles, as we've heard, stipulated the trial and punishment of those responsible for the genocide, of course not defined as such at the time. However, the framer of the concept of genocide, Raphael Lemkin, has said that the accounts of the massacres perpetrated against the Armenians by the Ottoman state, in fact, very much influenced his development of the term. So these articles had been inserted into the Peace Treaty of Sèvres, signed on 10th of August 1920. Crimes against humanity was the original charge, which was later changed to massacres. This had been opposed by the United States, who preferred crimes against the law of war, and by Japan. Yet the court provided for an Article 230 of the Treaty of Sèvres, never in fact eventuated. In fact, the peace treaty was abandoned, signed but never ratified. There was even a provision for a court to be the designated tribunal. And the successors to this treaty, the Treaty of Lausanne, omitted in fact all mentions of war crimes. So it was not the Allies who initiated legal proceedings against the perpetrators of the genocide, but the Turks themselves through the Ottoman Parliament. The Armenian massacres became the primary topic of conversation in the Ottoman Parliament, with one parliamentarian decrying that we inherited a country turned into a huge slaughterhouse. On 2nd of November 1918, a motion for a trial of the ministers of the two wartime cabinets was introduced by a deputy in the Chamber of Deputies of the Ottoman Parliament, invoking the rules of law and humanity. 2 inquiries were subsequently established in late November 1918, and the courts-martial were established by imperial authorisation on 14th of December 1918. Interestingly and importantly, the basis of legal proceedings was Ottoman law. The courts-martial prosecutors relied on the Ottoman Penal Code for the charges, and at least 63 trials were held, only some of them reported. And this has been a key issue in researching these trials and there being public knowledge of them. Much of the documentary evidence has been destroyed by the modern Turkish state. Over 200 files have been prepared on individuals, government, military and party officials alleged to be participants in the genocide, and these documents, these 200 files, together with the trial records, provide a substantial documentary record, albeit incomplete, of the genocide. There were 4 main series of trials within the framework of the courts-martial: the Itihadist leaders and Central Committee members, the ministers of the 2 wartime cabinets, responsible secretaries and delegates who had organised and supervised the deportations, and those of the special organisation who had done the killings, and officials in provinces where the massacres had taken place. But the ascendancy of Kemalism meant the demise of the courts-martial. On the 29th of April 1920, a bill was introduced in the new Kemalist National Assembly in Ankara to declare the official decisions and decrees of the Sultan's instable government null and void. On 31st of March 1923, a general amnesty was announced for all those convicted by the courts-martial as well as by civilian courts. There were endowments to families, streets named after these perpetrators. But we have these records, and this is something I've always found important, and one of the reasons that I've looked at this particular courts-martial. We had a courts-martial established at the end of World War I for these crimes, a very clear statement and recognition, authoritative acknowledgement of the genocide of the Armenians by the Ottoman states, and one that can be used to combat denial, continuing denial by the Turkish state. The question I want us to be thinking about is, how do we translate these judgments and these findings? How do we do the work of translation? And by translation, what I mean is, how are these heard? How are they understood on the ground, beyond the courtroom? How do they create impact? How do they create these foundational moments of change? How do we sustain these moments of judgment? How is this integrated? So Thomas Nagel has made a distinction between knowledge and acknowledgement. And Stanley Cohen, criminologist Stanley Cohen, noted, drawing on Nagel, that acknowledgement is what happens to knowledge when it becomes officially sanctioned and enters the public realm. And we can argue that this is law's critical role. There's always knowledge. Victims have knowledge, eyewitnesses have knowledge, perpetrators have knowledge. But it's law that creates this official acknowledgement and creates this potential to create change, through recognising the difference between the past and the present and moving towards a future. How do we create these foundational moments? How do we create this sense of shared humanity? How do we hear the victims and witnesses and their stories? How do we make visible the stories that are heard in the courtroom? When these are in courtrooms far away with limited public access, as often is the norm with international criminal justice. And as we heard just recently, it's not international criminal justice, but these mixed tribunals held in Paris, held in London. Today, international criminal justice held mostly in The Hague. We've seen that we have outreach activities being a new addition to international criminal justice, but I think that making visible is something different to what we might term outreach, which here very much focus on relating what courts are doing, informing communities, sometimes using innovative means such as drama. What we're looking for, I think, is an interactive process that needs to be established if we're going to have a sustained foundational moment, and the integration of these judgments, these processes, into the lives of national societies. Here, I suggest that we can use the records of law to create this. These can be hidden, so for the Ottoman courts-martial, but we can use them. We have many thousands of pages of records, transcripts of cases, of judgments. We heard about yesterday of the 4,000 boxes of the reparations claims that reside not only in international courts, but in tribunals and commissions of inquiries. So I've got the picture up. If we jump to the present day, the judgment most recently on genocide of Mladic at the International Criminal Tribunal for the former Yugoslavia. But we've seen this isn't translating into recognition in Serbia, for example. This isn't translating into the need to support Bosnian victims. How is the naming of genocide understood on the ground? What can be the impact of international criminal justice? If we go back to the Ottoman courts-martial, while there'd been public statements in the parliament and the media as to the nature of the massacre of the Armenians and great condemnation of it, the wider population, in fact, seemed reluctant to accept the legal process and its verdict. For example, a story that's told is due to the public unwillingness to accept Armenian testimony during the Yozgat trial, one of the trials in the provinces. In his closing arguments, the Prosecutor General told the court that he was intentionally excluding all evidence supplied by Armenian witnesses and was concentrating on documentary evidence and evidence supplied by former government officials. Those convicted, as I've mentioned, were later held up as martyrs. So with law increasingly addressing state crime, how law is heard, these laws and these judgments become increasingly critical. When we're talking about peace through law, these are critical questions. How do we translate law into peace? We're talking about settlement of conflicts. What is in fact required for this? I suggest that laws findings get heard, that they get translated into the ground, onto the ground. What do we do with these records, these judgments? I don't think these are foolish questions. How this work continues, how this is translated is, I think, critical, one of the great jobs that we have. I once wrote that we can forget as long as it is integrated into our institutional practices. Peace through law depends on structural change, that underlying structures that enable such harm and that are both cause and legacy get addressed. It's not sufficient to only change norms, structures must be changed too. So it depends on how we hear these judgments and these claims. And where judgments fall short, where they don't capture the harm, then we can use the transcripts, in fact, the claims made to law. So increasingly, we see this done through non-legal means, in fact, through art. And I want to give some examples of this in relation to international crimes. So this was an exhibition that was held and opened in Sarajevo in 2012, My Body, a War Zone. And it drew on local and international judgments for the International Criminal Tribunal for the former Yugoslavia and from local courts. It was shown in Mostar, Banja Luka, Requejo and Zenica. And Olivera Simic, who's done some work on this, has noted that many of the young people who joined the discussions stated that visual art in the form of women's portraits revealed stories that would otherwise stay buried in legal documents. It was designed as a key visual awareness-raising tool to demonstrate as well the need for an international protocol on investigation and documentation of sexual violence in conflict. These are the drawings of a Kurdish artist, Osman Ahmed, who I met some months ago, and he's done these quite extraordinary drawings of victims of the 1986 Anfal against Kurds in northern Iraq. So in the absence of a justice process, in the absence of legal judgment, legal testimony, legal transcript, he's actually been doing the work of creating records, creating this testimony to in fact create a space of awareness and recognition. And this is a project that I've been involved for a number of years now, called the Minutes of Evidence Project. And this draws on the minutes of evidence, the transcript of an 1881 parliamentary inquiry into an Aboriginal station in Victoria, very close to where I live in Australia. It was a parliamentary inquiry into the Corranderk Aboriginal Reserve in the colony of Victoria. So there were many British colonial inquiries held over this time, but unusually for the time, this particular inquiry heard evidence from Aboriginal people. It had been hard fought for, so the Aboriginal residents had already been dispossessed from their traditional lands. They'd been brought together in a number of stations throughout the colony of Victoria. They had petitioned, that's the top left is one of the petitions that they'd given and walked 120 kilometres from Corranderk to Melbourne to present the petition to the governor. They did this 4 times. The report of the Corranderk Board of Inquiry. This inquiry was held over a number of months, and we have this transcript, the minutes of evidence. We've turned this transcript into a verbatim theatre performance. We've partnered with 13 organisations, including the Education Department, 2 theatre companies, government organisations, community organisations, universities, to really have this story told. We've got new curriculum in schools, we've got this verbatim theatre performance, and the idea of the project has been to create meeting points in public spaces, in schools, in theatres, universities, and through research to really act as a catalyst for establish awareness of this time, and not only that, of the potential of how things might have been different. So what we see in the inquiry, and that's a still from it at the bottom, at the top, we have members of the Corranderk station. What we see in this inquiry are the claims that are made to law and the way that they're made to law. So we have the assertion of sovereignty. We have we can work the land. We can do it together. Let us use Christian law. So there's this sense of that we can work together, we can do this differently. And so in using this transcript and using the minutes of evidence of the Corranderk Board of Inquiry, we've been creating spaces for awareness, for recognition, and for establishing possibilities in relation to our nation's past, present and future. What's interesting in these examples, I think, and when I've spoken to art practitioners, they say this as well, is that art works on an individual, not a state level. It works in a different register to law. So if we're thinking about how law communicates these kind of grand foundational moments, it communicates to the society as a whole, whereas art very much focuses and communicates to the individual. And in terms of change, this can be very effective. But of course, we're thinking about different registers of change. We're thinking about structural change as well as individual and societal change. So when we think about translation, I think we can think about it in two ways. Firstly, that we need to have this story of accountability and of harm heard. So not just in remote international and national courtrooms, in beautiful buildings, but rather engaged with. So the story of accountability and harm that is narrated through our courts, through our commissions of inquiry, through our processes, must be heard. It can't just stay there. It must be heard on the ground. And secondly, these individual judgments need to be understood as part of a broader institutional and state crime. So we need to understand these judgments, these processes, particularly in relation to what we understand as international crime, crimes against humanity, genocide, war crimes, understood as state crime, not just bad people doing bad things, not just individuals. So what's interesting when I was looking at My Body, My War Zone, the Sarajevan exhibition, was that while this was done in part, it wasn't done in full. So the rationale for that exhibition was arguing that all women's stories must be heard. And that they argue that all, even though there were different gradations, all women's stories must be heard and they must be seen as equally harmful. And of course they were, and the individual harms in state crime are all equally harmful, absolutely. But something is taken away from the specific harm that Bosnian women faced as victims of rape and sexual assault as a tool of genocide when we take this kind of approach. And in fact, we could argue that in many ways this exhibition does echo the judgment, which was problematic in the way that it did represent the conflict. So my work has been very much focused on a concept of state crime. Who is brought to account? How is this particular crime understood? So we can understand these international crimes as state crime, perpetrated in the name of the state or the state-to-be. Genocide, crimes against humanity, apartheid. So that these crimes take their specific framework because they draw on institutional structures, armies, government structures, legal systems, and they co-opt those of civil society, churches, media, business. So Hannah Arendt was very clear on the challenges, particularly in relation, she was observing the Eichmann trial, of course, but the challenges to law. That many aspects of the trial demonstrated the inadequacy of the prevailing legal system and of current juridical concepts to deal with the facts of administrative massacres organised by the state apparatus. And I thought that was always a very apt statement for understanding what it is that's unique and particular about state crime. The purpose of state crime is very specific. It's engaged in nation building. And as Guy reminded us yesterday, law is very much engaged in the role of governance. So we see law coming in to address this. But we can't understand it as warring tribes or ethnic cleansing, as we see increasingly here, and it's quite a problematic term. So it's one of the things when we're talking, one key issue when we're talking about translation is translating as state crime, not just translating individual stories, individual harms, but translating these particular harms as state crime. Now, justice at Versailles, of course, was very much based on national and collective guilt, and this was, as we've been talking about, problematic. The Ottoman state was very much aware of this, and it was determined to identify the individuals and structures responsible. And if I just read to you from a newspaper editorial at the time, the newspaper Alamdar wrote, "The only thing that would help us is to cry all over the civilised world that we will really and actually exercise justice over the guilty. If Baghdad Square will not witness the gallows of the criminals, then Paris, the peace conference, will become the place of judgment of our state in our nation." So a consequence of this focus of Versailles on national, on collective guilt, has been that future international criminal justice has been very much focused on individuals and not on states. This was despite moves in the 1990s to change this. The International Law Commission attempted to create a charge of state responsibility, but kind of balked at the last moment. The individual accountability has been very much put forward as clearly a means of avoiding a kind of a norm of collective responsibility, and it's clear why we don't want to go down that path. Yet it also fails to capture the nature of these international crimes, and I think this is problematic, that these are not individual crimes, and sometimes this is missed in our judgments and our processes. So how does international criminal justice as a system of individual accountability then understand and translate state crime? It matters, as I've been discussing, how these findings are in fact understood as institutional and state crimes, that these are not just individuals doing bad things, but we need to be focused on not only individual harm, but state institutional transformation. International criminal justice is a system of individual accountability, and translating these is of great importance. I've written in the past about the concept of what I term civic liability. We have criminal liability, we need to be thinking about civic liability, that these institutions have abrogated their responsibility to civil society, and there needs to be some liability for that. We do have some tools in international criminal justice: joint criminal enterprise, joinder indictments, common purpose, individuals as members of organisations, addressing institutions, and so on. And the Ottoman Tribunal very much sought to allocate, and we can see this in the organisation of the trials, institutional as well as individual responsibility. The question I'd like us to think about is, well, what structures of oppression do these records of law reveal, and which do they hide? How are these translated? So how are these particular legacies, causes of these particular crimes understood in our judgments, in our commissions? We can see how the legacies of colonialism have been very much absent in legal records, for example. And much of my work recently, as you would have seen through the Minutes of Evidence project, has been focused on Australia and how we might understand a structural change. But I do ask myself as well, it's a question we can ask together, what would structural change look like elsewhere? What would it look like here in Europe? What was it meant to look like in the wake of Versailles? What new frameworks could in fact be created? Here, I think in all of this, we can use the record of law. We can use these legal records, transcripts, judgments, and we can reactivate them. One reason, as I mentioned earlier, that I've been so interested in the Ottoman courts-martial is that this is, aside from victim and witness testimony, the only authoritative statement of the fact of the massacres, of the genocide. These records, those that still exist, and the fact that the courts-martial was held remain as evidence. In a situation of continued denial by Turkey, this is important. So these legal records can potentially create new meeting points, new moments of understanding, new foundational moments in law and outside. But they need to be brought outside of law to be heard. We need to have all our reparation tribunals, judgments, our commissions, our 4,000 boxes of reparation claims unpacked and unveiled and made visible. These legal records can create new meeting points in law and outside, but they need, as I've said, to be brought outside of law to be heard, to make structural injustice visible. We saw this, for example, in another context with the case, and that's the photo top right, brought to the British High Court of Justice by elderly Kenyans, victims of British colonialism. And the case that they brought some years ago, and there are cases ongoing as well, relied very much on the record of law from the time. We've seen it as well in the way that Minutes of Evidence, that's a still from the play with Uncle Jack Charles as Barak, who was the leader of the Coranderrk station at the time. We've seen it in the way that the Minutes of Evidence project has created meeting points for recognition of Australian colonial harm and the connections between the past, present and future. If we want structural change, then we need to make the structural injustices visible. Maybe it's not through shooting the Speaker of the Hungarian Parliament, but in other ways. What gets told and heard at these tribunals and commissions? How are these crimes against humanity understood? What changes are made as a result? In a completely other context, the South African Truth and Reconciliation Commission held institutional hearings to change the structure of the state that had perpetrated apartheid. That these weren't in fact implemented kind of points to where South Africa is today. In Germany, we had extraordinary efforts made in the wake of the crime of the Holocaust by Germany in reparations, memorialisation and so on. But what about citizenship? It was only in the 2001 or so that we had a change in German citizenship for one based on blood and ethnicity to more of a civic citizenship, which would enable some inclusion of Turkish Germans. My colleague Nathan McMillan has looked at how colonial responsibility, particularly in relation to the Rwandan genocide, has been heard and not heard. And work I've done with colleagues in criminology at the University of Melbourne has looked at how we understand commissions of inquiry, what they make visible and what they don't. So law can be very much utilised in creating spaces to discuss this, to create awareness and change. What would structural change look like in Europe? What would it be about addressing the continuing fault lines of ethnicity, of religion and race? What does it mean to be a German, to be a Yugoslav, a previous Yugoslav? Ethnic nationalism, citizenship. These are questions I think we need to be thinking about in terms of structural change and how we might use law, and we might use law to create spaces to discuss this, to create awareness and change. So I want to leave the last word, just the last minute and a half, to Uncle Jack Charles, who was one of the actors of Corandurk, We Will Show the Country. The first few seconds or so is very much about his relationship to why he was asked to play this role, but it concludes on a reflection as to why this is important.
Well, I've been hooked up with the obituary theatre with Jack Charles versus the Crown, so I was in place in a unique position to be cast by Rachel, and it was because it's Aboriginal theatre, Aboriginal Torres Strait Islander theatre. Protocols have come into play here, and a bloke like me with my extended family up there, or my great-greats living up there at Corandurk, so it behooves me to join this group and tell the story of Corandurk.
Would you like the government to give you all the food you want and all the clothing and work?
We would like it if the government leave us here, give us this ground and let us manage Corandurk and get all the money. Why don't the people do it for themselves?
It's important for me to realise that I have relatives up there who were agitating with William Barack and many others to have the removal of the station management and to be independent and to be have that land permanently gazetted forever and after as their permanent home. And that was why this needs to be told. Corandurk is the most important story because this is the beginning of a journey for white Australia. It has to happen eventually, that white Australia will be, educated in Aboriginal history. Each state has their own stories, but this was the most significant. Victoria has set the bar here, the first state to invest Indigenous history, an important Indigenous history because it was the beginning of agitation.
Thank you. Thank you very much to everyone, and thanks, Jennifer, for this visual also. So the court, tribunals, criminal justice, perception, translation, how they're perceived by their institutional creators, by their public. I think there's a lot to discuss. I will give the floor to people for questions. We have some time, I think. And I think there's a lot. 10 minutes. No, we don't have time, so hurry up.
Hello? Yeah. Thank you to all the speakers for very engaging papers and talks. Excuse me for asking only one question to Dr. Jennifer Balint, and it concerns two things. Really, it concerns the expectation that we have of the law. And I want to refer you to two things in your talk. The one is the quote from Hannah Arendt's book on Eichmann. And secondly, the reference also to the South African Truth and Reconciliation Commission. Now, having also engaged quite a bit with Arendt's work and with Arendt on Eichmann in particular, I find her take on the impossibility of the deficiency of law in addressing this kind of, this kind of complete atrocity. I find it in a way very unsatisfactory, because as if she's expecting from the law to be able to deal with that kind of thing, whereas where it is not, one cannot really imagine a legal system ever trying to deal with something which is the complete breakdown of the legal system. There's something else, there's an intermediary step of creating a political system within which the law can begin to operate again. But for the law to go directly back to what happened then, to try and mete out a kind of proportional justice, Aristotelian concept, it's just impossible. For there, one would simply, in the case of Eichmann, her question is that, how do you punish him? Because there's no punishment for him. Well, you just punish him. You punish him in terms of what the law can provide, and get on with it. Get on with it, because a retribution of sorts will not take place here at all. And then this brings me to the Truth and Reconciliation Commission, which is, of course, heralded as also this incredible event of trying to come to terms with the past and the law's role in that. But what was actually happening there was a suspension of the legal system, which was in the long run, which became very detrimental to the rule of law in South Africa. And I would just like you to comment on these two aspects, please.
Thank you. Is there another question from the audience? Maybe we'll take 2 or 3 before giving in the back, gentleman.
Many thanks for the presentations. I had 2 brief questions. The first for Professors Hess and Isidro. Could you please explain about reparations in these institutions of mixed arbitral tribunals? Besides compensation and restitution, there were other modalities of reparation, such as rehabilitation, symbolic reparations. And my second question is for Professor Balint. You mentioned, or you referred to this idea of state crime. And as you know, this idea has been already, let's say, rejected by, among others, the International Law Commission. Although some scholars and judges, for example, Judge Antonio Cansado Trindade of the International Court of Justice, had been advocating about the notion of state crime. But in your opinion, which kind of consequences, including liability, criminal, civil, international liability, can be attached to this idea of state crime? Which kind of consequences? Thank you.
Just a very quick point of order. When you ask a question, please introduce yourself for the sake of our registration. Thank you.
Okay, yes. Yes.
Björn Laukemann, Max Planck Institute, Heidelberg. My question relates to Marta Requejo and Burkhard Hess. You just mentioned the openness of the procedural methods to determine applicable law on the one hand side, and the procedural imbalances as to the seat of the tribunals, for instance. Do these imbalances somehow are reflected or echo in the decision itself, that you can say that they were somehow imbalanced in the concrete outcome? Thank you.
So I will take one more question, and then I'll give the floor immediately to our speakers, Pierre, Would you please, Professor D'Argent?
Thank you. I will address short questions, comments to each of our speakers. They have been extremely interesting. On the PCIJ, I fully agree that it is an incremental system building way to look at those courts that is most helpful. The profession is obsessed with the World Court. We are like flies around light, and somehow there is also a paradox, because the statute says that we, the scholars, our teaching is a means for the court to, a subsidiary means to determine sources. But then when the court speaks, that's the end of it for ourselves. I mean, Laurence has very elegantly argued in favor of the existence of a customary international law rule regarding environmental impact assessment, and of course quoting cases, quoting scholarly writings for that purpose. And once the court says there is a rule of customary international law requiring environmental impact assessment, that's the end of ourselves. I mean, there is a case, and the case will be quoted for the future without reference to any teaching anymore. We disappear once the court has spoken. So there is a professional ambiguity through the incremental role of the court, which is interesting. On the mixed arbitration tribunals, of course, they reflect a liberal order. Property is at stake, and property should be protected. Of course, for certain citizens rather than others, but there's a reflection of a very liberal, property-oriented legal order. And then on criminal justice, that needs to be heard on the ground. There is, I fully agree, but there is also a risk in the sense, I mean, genocide exists officially as far as Bosnians are concerned, not as far as Croats are concerned. And of course, Croats resent the fact that their collective identity is unseen officially or ignored somehow, or could feel a finding of crime against humanity instead of genocide for that purpose. And all that is extremely ambiguous in a postmodern era when we say that we are made of multiple identities, but nevertheless the crime of all crimes, genocide, is predicted on singling out one identity that prevails and that needs to be somehow recognized officially. And there is, I guess, on the ground, when international justice is heard, it is heard very differently by those affected by the crimes, because the findings are different because of the proof that are collected, because of the legal reasoning of the judges. But to explain on the ground those differences while collective identities exist on both sides might prove extremely difficult and nurture conflict, unfortunately.
Thank you. So let's go to a round of responses. Maybe we'll take your comments and then...
So many thanks for the questions. Responding to the first one, whether there were something different from civil compensation in the mixed arbitral tribunals, no, they weren't. Actually, these were tribunals which were just dealing with civil claims. So it had nothing to do with having a day in court to tell a story or receiving apologies or rehabilitation or things like this. It was purely civil claims, so this did not exist. And the question of Bjorn regarding the imbalance, I have to say that I have read quite a lot of judgments of the mixed arbitral tribunals, because there is this Requejo where you can find not all of them, but many of them. I didn't have the impression that they were imbalanced, but the imbalance was actually and structurally there, in the sense that only the claimant from the allied country could choose whether to go to the mixed arbitral tribunal or whether to go to a national court. Counterclaims were not always admitted. So you had this, and also they were people, human people, in the sense that it was very difficult for the arbitrators probably not to feel inclined to solve according to the law which was more familiar, or according or following the interest of the state which was represented in the figure of the national But I think that you had found that in some mixed arbitral tribunals, the feeling of the national people of the country was not only Germans were against the mixed arbitral tribunals, but also the Polish. So maybe you can.
Yes, indeed. The perspective of this imbalance is very much from a German perspective influenced by writers in the 1920s. And there was a little bit a feeling that they had to continue the war in the mixed arbitral tribunals. And the same was also on the French side. We should not deny this. Also, the courts, to my opinion, were much more balanced. Of course, the provisions they applied, we have said this, were a little bit unfair seen from the German perspective. But we had also the situation in Upper Silesia. And there, indeed, it was rather the Polish side which was very much uncomfortable with the courts. And coming back to this question, what about reparations, what about property claims, what about personal damages? So the idea was reparations were about direct war damages affecting persons, and property claims arising out of the economic warfare were within the mixed arbitral tribunals. Regarding the Italian mixed arbitral tribunals, this was very harshly criticized because people said, for good reasons, cannot be. Those people who lost their lives, their relatives, etc., they do not have the day in court there, whereas property claims are handled there. So when in 1932 the mixed arbitral tribunal concerning Italy was closed, the Italian government established a specific authorities to deal with claims of personal damages. Yeah, so in order to substitute the mixed arbitral tribunal. So there was also this imbalance in it. But you can also look at it differently, and I come back to the property issue. It was a liberal idea of property. But if you look at it from today, you can also say it was a kind of untechnical investment protection. Investment was protected as far as it had been made within the belligerent states. So all investments of allied creditors were finally protected and compensated by the mixed arbitral tribunals. Maybe not all of them, but most of them. And in this respect, it's maybe even a precursor of investment arbitration.
Thank you.
Great. So thanks very much for some really interesting and thoughtful questions. Maybe just to start with the first couple of questions. Thank you for those. I think one thing that we need to think about is that let me start again, that there's a writer, Julie Mertis, who talks about, when she writes about International Criminal Tribunal, she says, the problem with international criminal tribunals is that they are international criminal tribunals. And she sort of then goes on to say, of course, how important they are and so on. But that there is this issue and this problem, and I completely agree, that we have these expectations of law that are unfulfillable. So we see increasingly that law should affect reconciliation, affect reconstruction. And if you go through like the mandates to so many of our tribunals, we'll see reconciliation as part of it. This tribunal will affect national reconciliation and so on. Well, will they? Can they? Should they? Is that the job of law? The job of law in many ways is accountability in judgment. We need to be very specific about that. But I think we can do that alongside an awareness of the particular types of crimes that we are actually addressing, that we can locate these individual harms within the broader processes within which they are perpetrated, these state, institutional, nation-building processes. And that, look, it is problematic if we start thinking about, well, this is impossible, we can't do this. I think we can. And there are very specific ways, and we see law doing this in specific ways. So I think with the joinder indictments and so on, or in the International Criminal Court, within the definition of crimes against humanity, notes that these are crimes perpetrated or committed in furtherance of a state or organisational policy to commit such attacks. So it's very much locating them. So I think law is doing some work at that, but what I guess I'm arguing as well is that how we translate them, how do we, and all of this tends to get left out somehow, that these are just individual generals, mayors, prime ministers, presidents, so on, who perpetrated particular acts rather than locating them in what I suggest we see as state crime. In terms of the TRC, yes, TRC has gone and had its absolutely been problematic in many ways, and that the fact that you couldn't do criminal trials, and you as you were saying, is, if I understand you correctly, that the rule of law was superseded in that way, and there was a lot of angst and a lot of disappointment by victims that they weren't actually able to, and that's sort of, there have been some criminal trials since then, but that wasn't at the time. I think, to me, what was important about the TRC is in the way in that it actually identified the institutional structure of apartheid in a way that a court couldn't. That these recommendations were not taken up by the government has been the problem, in that they were very clear recommendations for structural change. But I think that could have been done alongside some criminal prosecution. I think was potentially a missed opportunity there as well. The concept of state crime, I guess I'm answering that in part in this question, in that we do see that concept incorporated in some of our current processes. And yes, I mean, clearly that was rejected by the international legal community. I think that was unfortunate. But if we understand an act as state crime, it also helps us understand prevention. If we're thinking about peace through law, we need to be thinking about, well, what was the act? And I think it's only when we think about it as a state crime that we actually understand the particular way in which it was perpetrated and the particular ways in which we might actually create an ongoing structural justice. So that's that I believe is an important aspect to that. And yes, in terms of it is interesting, the question in relation that the risk in terms of when we're trying to establish like a multi-ethnic space, that we're then going back to, well, this particular ethnicity perpetrated this against this other ethnicity. And I think that's where a state crime approach actually can be really helpful. And certainly in the wake of the Rwandan genocide, there was hope that rather than saying the Hutus perpetrated the genocide against the Tutsis, that a more political approach would be taken, a state crime approach, saying that the government, this was a state-perpetrated crime and we need to address it as such and not try and put 100,000 people in prison and then establish a situation in Rwanda where it's very much seen as an ethnic crime. And the same way, potentially, although I would say that it does need to be heard, that genocide was perpetrated, I believe needs to be heard on the ground in Serbia and has not been. And in order for there to be any the full acknowledgement, but it is problematic, and so we can thank Dayton for that as well, in that the way in which they solidified the three identities that Bosnia in many ways was trying to get away from with its creation of independence and a society which saw itself as cosmopolitan, a sense that's where people didn't actually identify in that way, and so they've been forced into this, ethnic identity. Thank you.
Well, thank you. One line about Croatia, Serbia, Bosnia, and the Yugoslav war. I mean, I appreciate the idea that Croatians were disappointed, and you spoke to that. I will only simply mention one fact, that the bombshell that was in the ICJ proceedings, the claim by Serbia that Croatians had committed genocide by driving out large numbers of Serbians from territories in what is now Croatia. Now, that was unsettling at so many levels, but I think one of the reasons was that it was a claim that whatever its legal merits, it shook the perceived perception of the case. So all of a sudden there were Serbian victims to a conflict which, however one may see the respective roles of Croatia, Bosnia, different ethnicities from within Bosnia, they might also would also need a response from the law. But that's as an aside. I wanted to respond briefly to Pierre's question, which is about our obsession with courts. And I do think, I fully share your diagnostic aspect, if you want. We are obsessed with courts. I think I would even go further. It's so problematic because there's so few courts, and still we obsess about them. And rather than making use of, or rather than seeing that as a strength in our understanding of how law operates as international lawyers, namely engaging with the richness of processes of applying and enforcing the law, we're restricting ourselves to sort of a focus on courts, the one modality which maybe covers, I don't know, 5-10% of the disputes in international law, and still we obsess about it, rather than sort of speaking to others who do other branches of law and tell them that we actually have more to offer because we engage with the richness of making the law heard, not just channeling everything through the lens of sort of a court process. But I suppose it speaks a lot to hidden inferiority complexes of international lawyers, that it's only if it's before a court that it's real law. And finally, we do have courts, and this is why where we have them, we need to obsess about them. But of course, who am I to point fingers? I mean, I'm part of the problem. Final point, do we disappear? I mean, that was the sort of the, if you want, your prognostic aspect. I'm not quite so sure. You could also look at it from a different angle. You could see in the emergence of courts with different levels of receptiveness, a new audience. Now, you spoke to the International Court of Justice, which is not the court that is renowned for openly engaging or taking on board thoughts written down by writers, but there are other approaches, and you might see as a new sort of purpose of sort of writing and sort of influencing more directly outcomes of court proceedings. If you are right, and to say, well, look, if a court has pronounced it's the end of the matter, at least where we have centralized systems, not fragmented systems, then I suppose it reflects our desperate longing for order in a discipline that perceives itself so much as a cacophony of voices. And then maybe it's not so bad after all. Thank you.
It's not so bad after all. But we have, Pierre, a schizophrenic relation with courts, especially the court. Of course, international lawyers tend to criticize decisions or for whatever reasons. But on the other hand, usually most international lawyers wait with great expectancy to hear the court speak when it speaks, from up there in The Hague. So I think we need a very, very short break, I imagine, so we can come back to, 20 minutes break, terrific. I mean, then we'll be back with two substantive approaches to court dispute settlement. Thank you, everyone. And thank the